What's the topic of your discussion today?
The topic of today's video blog is time limits in family law.
Why are time limits important?
Time limits are very important in family law because if you don't get into the court in time, or if you don't resolve your issues in time, then you may be barred from pursuing those issues. Every jurisdiction's got its time limits. You've got time limits in commercial law, personal injury, and family law is no different.
What time limits are there?
Yes. So in family law, you're looking at three main areas. You're looking at child support, you've got children's issues, and then you've got financial issues. And the time limits vary depending on the area that you're looking at. But in addition to those strict time limits, you've also got rules of thumb, which I'll also talk about. So when you're looking at child support, you've only got a very short time in child support. You've generally got 28 days only, and that time frame is very strict, and so you've got to lodge any objection or apply to the State Administrative Tribunal within those 28 days, or you'll potentially be barred. When it comes to children's issues, there's no strict time limit per se. There's a rule of thumb that, as far as children goes, no orders are ever final. But as a rule of thumb, the longer you leave the situation in place and the longer you don't apply to the court to change it, then the less likely the court will change that situation. So the rule of thumb for children's cases is don't wait, don't delay, and make sure you address any issues promptly. When it comes to financial issues, there's quite strict time limits as well. You've got obviously a difference between married couples and de facto couples. And when it comes to married couples, the rule is you've got 12 months from the date of the divorce. So it's the divorce that starts the time limit from running. If you haven't got a divorce, then of course the time limit continues to run, doesn't run. And I've had cases where parties have been separated but have not divorced, and it's been 9 years and both parties have moved on, and both parties have repartnered and bought new homes and done their own property settlement, but they haven't formalised their property settlement with consent orders. And so in terms of those that time limit, they haven't had the divorce, and so both parties were still able to apply to the family court to pursue financial issues. With de facto couples, the rule's different. The parties have a strict 24 months from the date of separation, and so there's no obviously requirement for anyone to lodge any forms or documents. It's from the date that you separate, you've got 24 months. And so the problem with obviously de facto couples is there's no formal document to state when the date of separation was, and so parties can often get a dispute about when the date of separation was, and then the parties will obviously potentially have a dispute about whether they're in or out of time. The key, I think, the rule of thumb with de facto couples and with married couples when you're looking at financial issues is don't delay, get advice as soon as possible, and address the issues sooner rather than later. As is widely reported in the press, there's no hiding from the fact that the family court is heavily overworked. There are significant delays in the court. It now takes up to 2 years for cases to go from the commencement of proceedings to a trial, if that's what the parties need to do to resolve their dispute. And so, there's no point delaying, and there's no benefit to delaying a resolution of the case when, the potential minimum delay is a period of 2 years. So if you wait, 12 months or 6 months before you start to address these issues, then, you're going to add that to potentially the 2-year delay. Of course, not everyone's able upon separation to deal with these matters straight away. I mean, in theory, you can deal with financial issues the day after that you separate. There's no requirement to wait. Unlike a divorce where you have to wait the full 12 months, when you're dealing with financial issues, when you're dealing with children's issues, you don't have to wait. You can start dealing with the week that you separate, or you can have those discussions even before you separate if it's possible. There's really no reason why parties should wait, especially with the huge delays, and unless there are sometimes cases and factors where a delay is in a party's interests, but parties ought to get legal advice before they make a conscious decision to delay and wait before they address their financial issues and look at getting consent orders or anything along those lines, like a binding financial agreement. With regard to divorce, there is no time limit on getting a divorce, but the parties have to wait the mandatory 12 months from the date of separation before they can apply for a divorce. And it's often hear clients saying they've been advised, don't divorce, wait, resolve the financial issues, resolve the children's issues first. But I think the general rule is get your divorce the day after the 12 months has elapsed. Don't delay getting the divorce. There's really no reason why parties should wait, especially with the huge delays, and unless there are sometimes cases and factors where a delay is in a party's interests, but parties ought to get legal advice before they make a conscious decision to delay and wait. It has time limit implications for your financial settlement. It has estate planning implications, and there's no reason to delay getting the divorce. Often I think that advice is given for what I would say is tactical reasons, but as a general rule, when you analyse those reasons, I think they don't stand up, and you should just get your divorce as soon as possible. Both parties, if you've separated for that period of time, it's not likely you're going to reconcile, and there's very rarely a valid reason to hold off doing a divorce.
What can you do if you're out of time?
Yeah, so the time limits that we've mentioned, they are strict time limits. They are enforced, and to get around those time limits, or to apply what we say out of time, is expensive. It's not guaranteed, but yes, it can be done. You'll need to get legal advice as soon as you can. Once, if you feel that the time limit has elapsed on you, we often have to give people advice about that. Some people, for example, don't know about the time limits. I often give advice to facto couples. They say, we had an agreement, we didn't document that with consent orders, and I say, when did you separate? And I say 4 years ago. I mean, technically speaking, they're out of time, but you're able to apply out of time. But don't hang your hat on that. There's no guarantees, and there are strict conditions that have to be satisfied before you will be given leave by the court to apply out of time. So you don't want to find yourself in that situation, but if you are in that situation, you need to get legal advice urgently, and your lawyer may be able to help you in those circumstances. But there's no guarantee, so don't, as a general rule, let yourself be in the situation where you're applying out of time. It certainly, from a negotiating point of view, puts you on the back foot, and you know, you don't want to find yourself in that situation.
What do I do if I'm concerned that I'm out of time?
Well, it's, as I mentioned before, you don't want to be out of time, but if you are, you should go straight to your lawyer. I mean, you need to go and get legal advice straight away. You know, you can't wait around, you can't delay. You need to get on the phone, ring a number of law firms. You know, I know a lot of law firms are very busy, and you may not get in for a month. It's not good enough. Find a law firm that will see you, that specialises in family law. They know, ask them whether they've ever dealt with out of time applications, and you want to see someone that week. You need to go and see them without delay. You can't say, oh, you know, you might have other commitments in your life. You might be working FIFO and you have to leave for work. You've got to cancel that. You've got to go and see your lawyer straight away. Like I said, if you're out of time, there is no guarantee that you will be allowed to seek redress from the family court. And what that effectively means is you may be stuck with the legal entitlements as they are. That may or may not be a good thing. Generally it's not a good thing, because normally the assets are all tied together. So for example, the home might be jointly owned, in which scenario if you're out of time, that's, you know, a 50-50 proposition, and that may be a disastrous outcome. So you've got to go and see a lawyer straight away. I mean the next day or that week. You can't wait.
Do you have to go to court if you're out of time?
If you're out of time and the lawyer feels, or your legal representative feels that you've got a good case to be allowed to apply out of time, the lawyer can write to the other party, and indeed that's best practice, to send them a request to proceed for your financial settlement, or we're talking in relation to the financial settlement here, to ask for them to consent to proceed out of time. If the other party consents, then you will be allowed to proceed out of time. The problem, of course, is if they don't consent, then you may have those problems, and then unfortunately you will have to apply to the court, and that's where things get expensive, and that's where there's a lot of stress and uncertainty, and a lot of people can't afford to spend that sort of money to simply get over that first initial hurdle to be out of time. So it's certainly something you don't want to have to do. You'd rather spend your money on other things, and I'm surprised that this still happens. I suppose it's not known. These time limits aren't well known, and life's busy, and there's a lot of distractions, and so it's also hard to deal with these issues, so people often don't address these things in a timely manner, and they find themselves out of time. And then if the other party's not going to agree, then you're going to end up having to spend significant legal costs to potentially go to court. But the rules of thumb, they're not something that's written in the legislation. That comes from experience in family law, dealing with family law day in, day out. And the rules of thumb, they're only general rules, and parties need to get advice from a solicitor, and not rely on that rule of thumb may be totally inapplicable to your case, but the general rule is don't delay. I mean, there's generally it's not going to be in your interest to delay your case, and if there's one thing I want people to take out of this blog is don't delay. Get legal advice as soon as possible.
What do I do if the other party doesn't respond to my emails or letters?
Yes, the other party, often on separation, one person may not be ready emotionally, mentally, to deal with the matters that need to be resolved and sorted out when parties separate. And it's not uncommon that one party won't address the other party's emails or questions or proposals for settlement and things of that nature. Or sometimes they will respond, but they won't respond on point. They'll have a rant about something that's completely unrelated or something that's totally different. The net effect being the same, that you're not able to reach an agreement. You need to get advice as soon as possible and commence the next stage of the process, which in relation to financial matters is the pre-action procedures, and in relation to children's matters is family dispute resolution. You can't wait. You shouldn't wait. Some people will wait, a number of months before they take any action. I think that, as a general rule of thumb, if parties can't resolve the matter within 1 to 2 months of separation, they need to get legal advice. I mean, you're just adding to the stress. You're adding to the delay by waiting. I note that with child support, obviously it's a bit different. Those delays are much stricter, 28 days, and those delays are in the fine print at the bottom of your assessment letters and any judgments or decisions from the CSA. And clearly, what we've been talking about, in terms of property settlement and children's matters doesn't apply. With child support, you've got to get advice as soon as you get any decision. So, you don't want to wait around for that.
Did you like this video? Or would you like to see more videos? Then please like our Facebook page, subscribe to our YouTube channel, or follow us on Twitter or Google+. Just click on one or more of the links provided here, or leave a comment on our YouTube or Google+ pages.